All right, thanks everybody for hanging in. You're going to be well rewarded because I know this is going to be a very exciting panel. It's my pleasure to introduce Madeleine Lewis, who's going to moderate this panel for us. Madeleine is also a University of Wyoming and JDMA graduate from the University of Wyoming, and she's currently a associate research scientist with the School of Energy Resources, and she works in Professor Righetti's Jurisprudence of Underground Energy Law and Research Group, or JUL. So I'll turn it over to you, Maddie, and I'm excited for this panel.
Great. Thanks, Temple. And like she said, thank you for all of you who are still here with us today. It's been a long but really awesome day of presentations, and I'm just excited. I was really nerding out as I was looking over our speaker bios, and I had the chance to meet these remarkable women as we were preparing for this, and the wealth of knowledge on this stage is just really impressive. So as you heard from the previous panel, there's a number of obviously novel, really exciting energy technologies that are currently emerging in Wyoming and throughout the broader region. What's also changing, as many of us are aware, maybe painfully aware, is the legal landscape through which some of these projects are permitted. That includes changes to NEPA, which has undergone a large upheaval in the last year or so. So to bring it home and conclude the conference for today, these panelists will be talking through some of the reforms at the federal level for permitting. So first, we'll hear from Dessa Reimer. Dessa is an attorney of counsel in Holland and Hart's Jackson Hole office, where her practice focuses on federal environmental regulations, Indian law, and other areas of environmental and energy permitting and litigation. So her presentation, titled Rewriting NEPA, will focus on some of the legal and policy dimensions that have unfolded over the last year or so. Next, we'll hear from Nada Culver, who has served in a number of really impressive roles, including recently as Principal Deputy Director for BLM. Prior to that role, she was with the National Audubon Society and the Wilderness Society, and she's now a partner with Nashoba Consulting, where she focuses on public lands advocacy. So building on the groundwork that Dessa will lay for us, Nada will be speaking about agency actions and implementation of reforms. We'll next hear from Pilar Thomas, who is a partner at the firm of Quarles and Brady. She brings extensive experience in federal Indian law, having also developed expertise in various roles at DOE, Interior, and the Department of Justice. Her talk will focus on federal permitting reform in Indian country. Last but not least, we'll hear from Anna Gutierrez, who is a partner at the firm of Womble, Bond, and Dickinson in Denver, where she serves as head of their environmental practice. So like our other speakers, Anna has extensive experience on environmental regulations and permitting, which she uses to counsel clients on compliance and other issues. So her presentation will bring us home with a discussion of recent landmark cases and litigation that demonstrate ways in which courts are involved in reshaping the future of federal permitting. So when we're done with each of our talks, I will open it up to audience questions directly. I do have some canned questions, but I'm hoping and pretty sure that you'll all have questions too. So with that, I give it to Dessa.
There we go. Thank you for the introduction, Maddie. I'm Dessa Reimer. What was left out of my bio is I am also a graduate of the University of Wyoming, A&S, and also the College of Law. It's always my pleasure to come back and speak here at the University of Wyoming. I'm actually filling really big shoes today because on the planning committee, I did not put myself up for this talk. Ted Bowling was going to be here, and many of you know he used to be the director of the CEQ and obviously is a wealth of knowledge, and so I'm filling in for him today, but I'm really excited to be on this panel of distinguished women, some of whom got the message from Governor Freudenthal about government service, and really grateful for the time that they've spent in policy. Any one of them could give this talk today, and maybe some of you in the audience, so hopefully I don't bore you, but I'd like to cover two main issues. One, I'm going to set the stage for where we are in terms of NEPA regulation, and then I'm going to talk about the SPEED Act. And so, we had an earlier speaker talking about NEPA reform, which is apparently been around, for decades. What it was old is new again, and so we're talking about it again under the current Congress. And so I'm going to talk about the SPEED Act, what's in it, what's not in it, which might be even more interesting. So let's talk about NEPA regulation, and it's going to become apparent on my next slide when I talk about the regulations why I've used this graphic, because everything is on the chopping block. So let's start with the regulations. Originally, the regulations were promulgated in 1978. The Carter administration had issued an executive order, told the Council on Environmental Quality, go forth and promulgate regulations for uniformity of NEPA review. That all came to an end this year under the Trump administration. One of the first executive orders, Order 14154, withdrew President Carter's 1977 order. There was question from the courts as to whether the CEQ had the authority under NEPA to enact regulations, and so the Trump administration, acting on that, directed CEQ to withdraw the regulations, and that was effective in April. So we no longer have guiding regulations that are mandatory on all agencies. At the same time, in that same executive order, President Trump directed other agencies who engage in NEPA review to review their own regulations and to look at them in terms of the priorities of the new administration to expedite and make NEPA review consistent. And so in early July, we had a number of agencies put in place new agency-specific regulations, and those have turned out really to be skeletal. What they've done is taken what used to be in the regulations and they've moved it to the category of guidance. So what's left, for example, in the DOI NEPA regulations, which have gone from 42 to 6, is basic regulations covering use of emergency procedures, applicant-prepared NEPA documents, and categorical exclusions. Everything else is in the guidance. And then the guidance itself is returning to concepts from the Trump 1 administration and its first overhaul of the NEPA regulations, putting back in place 2020 concepts. So that includes, the removal of any reference to cumulative impact review. There's no requirement for public comment on draft EISs anymore. There's no but-for causation in terms of effects analysis. So we really are seeing things moving to the guidance. And then I know Nada's going to cover this in a little bit of detail as well, so I'm not going to talk about it much. And our earlier speaker, Alex, talked about alternative NEPA, but that is also brand new for energy projects in an attempt to really abbreviate the NEPA process. And Nada's going to talk about that some more. Now, I also don't want to step on Anna's toes because she's going to talk about 7 County in detail, but I just have to mention it because when we talk about the SPEED Act in a minute, some of the provisions of the SPEED Act are really attempts to codify the principles that were set out by the Supreme Court in their May decision of this year. So that case is what the court self-termed a NEPA course correction, and it has 2 main elements. The first is that the courts need to be giving agencies substantial deference in NEPA review cases under the APA. Courts are not to micromanage agency choices so long as they fall within the broad zone of reasonableness. This isn't necessarily different in concept from what existed before, but it's a reminder to courts that APA review is supposed to be substantially deferring to the agency's judgment calls when it comes to the scope of NEPA review. And then the second piece of that case is that environmental effects analysis need to really focus on the project at hand. Those are the effects that are relevant to an agency for its decision-making process. So if it's not responsible for those effects, if they're effects of other actions, they don't need to be incorporated into the NEPA review. So there's this question then in this changing regulatory landscape and with the U.S. Supreme Court's decision, are those changes really durable? And I think previous speakers have alluded to the fact that really regulations can be changed in a relatively short amount of time. And of course, the more NEPA concepts and requirements you put into guidance, a new administration can come in and the pendulum can shift, and then we're back to concepts from the prior administration. And so how can we make these changes to NEPA more durable? There has been a bipartisan acknowledgement that NEPA reform is necessary because of the extensive delays and the length of NEPA documents. And so one of the, really actually the first major changes to NEPA that we saw on this front were in 2023 in the Fiscal Responsibility Act amendments, and also called the Builder Act. The main elements of those changes that we're going to build on here when we talk about the SPEED Act are the inclusion of the concept of reasonable foreseeability, which is now a requirement in terms of what types of effects you have to look at for an agency action. And also the NEPA deadlines. These do include exceptions. The agency can get an exception to the 1-year or 2-year deadline for EISs if in consultation with the applicant, they need additional time to complete the review. And then the 2023 Fiscal Responsibility Act also includes page limits for project documents, as well as the concept of project-sponsored NEPA documents. Prior to 2023, the regulations allowed for EAs to be prepared by project proponents, but not EISs. So now there is the ability for project proponents to do that. Again, all with an, at least ostensibly, with an effort towards efficiency, so that if a project proponent wanted to take the wheel and put in the effort, they could get to a final document more quickly. Then more recently, in terms of making reforms durable, we have the NEPA amendments in the One Beautiful Bill Act of 2025. This is the project sponsor opt-in fee, and basically if you declare that you'd like to use this opt-in fee, you apply to the CEQ. Within 15 days, the CEQ has to figure out what the cost of preparing the NEPA document would be, and then give you a chance to pay 125% of that fee. And if you do that, you cut your NEPA deadlines in half. I think one of the more interesting pieces of this new provision in NEPA is that that deadline now no longer is subject to the exception process from the Fiscal Responsibility Act amendments. So that is a hard deadline. For EAs, the deadline is 180 days, and for EISs, now you're down to 1 year. But I'm not aware of any project that's attempted to use this provision yet, and maybe Nada will talk a little bit about why this would be a difficult. I don't have any client that's interested in doing it. Let's just put it that way. Okay, so then let's talk a little bit about the SPEED Act. I'm going to talk about what's in it and what's not in it, but it really is a bipartisan effort introduced in the House in July by House Natural Resources Committee Chairman Bruce Westerman, Republican from Arkansas, and U.S. Representative Jared Golden, who's a Democrat from Maine. And there is this consensus that something needs to be done in terms of permitting reform and NEPA reform, but really, what is it exactly? And the devil's in the details, and whether this is actually going to get reported out of committee and become law is, I think, a big question. Two of the main objectives that I see when you read the SPEED Act is, one, to codify what 7 counties said in terms of the standards of review and the scope of NEPA, and also to put limits on judicial review. And that would be an entirely new section to NEPA, and that has not been in previous efforts. So that would be, I think, a big change. So let's talk in just a little bit more detail about what's in it. The first proposal is to define NEPA as a procedural and not a substantive statute. That's not necessarily controversial on its face. I mean, there's hundreds of cases that say that. The Supreme Court has said that. But it does perhaps undercut Section 101, which arguably, NEPA is our national charter on the environment. And so that there is some conflict there. There are provisions of NEPA while the EIS process is procedural. The statute does have substantive aspirations for protection of the environment. There's also the scope of review provisions. This is directly an attempt to codify 7 county that when an agency looks to what it's going to include in the effects analysis, those effects have to be have a reasonably close causal relationship with the federal action. They're not speculative, they're not separate in time or place, and they are not in relation to separate existing or potential future projects or actions. The one that I find most interesting is separate in time and place, and I know the Supreme Court used that language, but there are arguably direct effects of federal actions that could be characterized as separate in time and place. I mean, if you think about invasive species, when BLM permits a new road, the invasion of those maybe plant species can take time and may not be in exactly the same place. So I think that including this type of scope provision is going to invite some litigation about what is separate and in time and place. That was pretty easy to define in 7 County. I'm not sure it is on a project by project basis. The next change in the SPEED Act is in terms of the deadlines for NEPA review. Rather than agencies being able to basically unilaterally extend NEPA deadlines, those have to now be approved by the applicant. It's not just a consultation process, it's an approval process. And then there's changes to the definition of reasonably foreseeable that really are in alignment with that scope of review provision. So if you read those, they follow closely. The second element of the SPEED Act is the limits on just judicial review. And I would argue, and at least the literature and the news out there, is that this is probably the most controversial piece of the SPEED Act. It's the first attempt really to limit in a big way what's available in terms of challenging NEPA. And there is an acknowledgement that the judicial machine of review under the APA of NEPA decisions certainly has been a driver for longer NEPA documents, more extensive review and delays. So maybe some of this is necessary and maybe some of it isn't. We'll see what happens. But the first proposed change is this codifying of the substantial deference standard that was in 7 County. One of the problems with this, and I'm counseling several clients who are commenting on this particular provision, there's a lot of concern about the standard of review provision in the SPEED Act, because the way that it's drafted currently, it appears to completely replace the APA arbitrary and capricious standard of review, which has built-in discretion. And so there's concern that substituting the substantial discretion standard, which isn't even the precise language from 7 County, could cause more litigation. How are the courts going to define that? The second piece of the limit on judicial review on the standard of review is there's a proposal that a court cannot find a NEPA error unless the agency would have reached a different result with respect to the final agency action, absent such abuse of discretion. So that is essentially baking in a harmless error standard into the merits decision for NEPA. And also, in my opinion, this is only my opinion, seems to conflate or confuse 7 Counties vacature language and attempt to include it in the standard of review. So maybe a little esoteric and nuanced, but I think if that ends up in the SPEED Act, that's going to be really difficult to parse out how that's going to apply. Running through the rest of these fairly quickly, there's a proposal that remand is basically the only remedy. Vacature is no longer available, and when an action is remanded to the agency to fix a NEPA error, they have 180 days to get it done. There's a statute of limitations, so this would replace the 6-year APA standard statute of limitations with a 150-day statute of limitations. There's also a limit on standing, so the only parties that can bring a NEPA case are those that submitted substantive and unique comments that cover the precise issue that they're challenging. Now, that limitation will only apply, obviously, to NEPA documents that are submitted for public comment. So if the agency goes the EA route and there's no public comment period, that limitation is essentially meaningless. And then judicial decisions have to be completed within 100 days of filing of the administrative record. And agencies get 30 days to file the administrative record with the court after the complaint is filed. So very abbreviated and sped up time processes for litigation. Whoop. And then the last thing I just wanted to cover is what's not in the SPEED Act. I think this has been alluded to before, but you can put all the deadlines you want on NEPA, but you have to have the people to get it done. There's no appropriation for agency staffing, of course, in the SPEED Act. And the crunch on agency employees is a real thing right now. There are other alternative bills that would put original jurisdiction for NEPA cases in the courts of appeals. That is not in the SPEED Act. There is no project proponent right to appeal. And this is basically the phenomenon that a challenger to an agency action, if they lose and the agency action is upheld, has the right to appeal to the courts of appeal, but the same right does not fall to project applicants. If the agency decision is remanded, there's the administrative remand rule, which forecloses a proponent from challenging the finding of NEPA error if the federal agency does not also appeal. So folks have thought about putting that in. And then the last one that I think is really important, and this is circulating in industry groups of all kinds in the energy industry, is to include a provision that protects permit durability. I think the Trump administration, with its attacks on wind energy, and you see them pulling back and preventing the construction of wind projects offshore on the East Coast that have permits that are 2 years old. There's a lot of concern that under this administration it might be wind, under the next administration it'll be a different industry. And so there's language circulating that would add to the SPEED Act a permit durability provision. And that's all I have.
Okay, thanks, Dessa. My topic is just going to tear off of Dessa's kind of the next level of this is agency actions and the implementation of the federal permitting reform. So the view from that of, as we're looking at this different approaches to streamlining in its various forms, what does that look like from the viewpoint of the agencies carrying it out and the public who's kind of experiencing that? And here we're seeing a different emphasis on what we're streamlining, and it is early days, so obviously we're kind of predicting how that's going, but it is a common theme. Each administration is going to streamline something, and it's going to be new and improved, and it's going to be faster, and it's going to be better. So this is a common theme, and we're going to see different emphasis, but again, we've seen this before, and what I think is common each time is you still have to do the work, all the work. And that might take some time, so no matter how much we're excited and we're streamlining and we're cheering, the overarching issue is we do still have to comply with these laws. So NEPA, for example, it's still in place, still there, not dead yet, and it still requires assessment of environmental consequences before you make a decision. It still requires the use of reliable data. It still requires the evaluation of alternatives. It still requires the consideration of mitigation. It still requires the involvement of cooperating agencies. Notably, the National Historic Preservation Act and the Endangered Species Act also still require compliance. So that work still has to be done. And that kind of is the theme here. You're going to see that throughout what I'm going through here. One other element that we didn't touch in the other parts of NEPA is FAST 41. That title comes out of the Fixing America's Surface Transportation Act. It now has been used previously to speed up other types of projects, and it gave rise to something called the Permitting Council. And in April, the Trump administration announced that it was going to apply to critical minerals projects as well. It had previously been applying to a lot of different kinds of infrastructure projects, but now it applies to critical minerals projects, had not applied to mining before. And these are the 5 projects that it announced in April. There's phosphate projects, copper, lithium, and coal. And what happens is once you join the FAST 41 party, you get added to a permitting dashboard, And you can go online and track your project as to how it's happening and where it is on the dashboard. And there has been some question over the years of whether or not this actually does lead to more efficiency. The idea is the additional oversight of it being on the dashboard means that people are watching and check your project all the time. What it also does, though, is if you change the schedule by so much as 2 days, you have to go online and change everything. So it's a lot of work for the agency. So if you think your project needs more attention, there's a benefit. If you think your project needs just a lot of work, there is a question. I would note that of these 5 projects that were announced in April, none of them actually appear on the permitting dashboard. So if they needed more attention by being on the dashboard, so far they're not there. A couple of the ones I checked are a little bit behind the schedule that they are supposed to be on. But we'll see how the additional attention goes for them. So the energy permitting procedures that were mentioned before, again, interesting, like FAST 41, you have to opt in. So you have to explicitly affirm in writing you want to be covered. And again, as we heard this morning, if you opt in for an environmental assessment, it's going to be 14 days. For an environmental impact statement, it's going to be 28 days. But again, what's interesting here is you first have to do other NEPA. You may be looking at a project, right, where you're doing energy, non-renewable energy, and may involve leasing and siting and transporting and refining. But to get to this part, to get to the energy emergency permitting, you have to already have something in place. You have to have a lease. You have to have done the NEPA to open an area to leasing, to issue a lease, to submit a mine plan of operation. So again, there is a lot of work that's been done already to comply with NEPA, to comply with the National Historic Preservation Act, to comply with the Endangered Species Act. So there is work being done. These are the 2 projects that have been completed so far under these procedures. We mentioned this morning already the Velvet Wood Uranium Vanadium project in Utah. This project was actually submitted in early April. The announcement of the emergency procedures was a little bit later in May, so that it could be announced to be completed in 11 days in May, but we'll just give them credit for that anyway. Congratulations. And the project itself, though, was permitted back in the 80s. At the time that the second permit was issued, the mine had not been permitting since the 80s. The site had reclaimed and was covered in reclaiming vegetation, and the project here was to update the plan of operations to allow the company to go in and begin clearing and creating infrastructure on an entirely new part of the site. So while the permit was issued, to actually do the development of the mine is going to require quite a bit of work. And additional permits are needed. So when we talk about doing the work here, it's actually work on the ground, but also getting permits, for example, from Utah's Division of Oil, Gas, and Mining. They just received that, I think, in the last couple of weeks to start the actual construction to do the work. And while there was no public comment permitted during this process, and they were doing a rushed job to get the National Historic Preservation Act work done, what is interesting is the BLM in this case did take the time to do individual meetings with each of the tribes that requested consultation. So here you see the agency taking the time to make sure that law was fully complied with. The other project here, Black Butte Coal, is an environmental impact statement. That one was done. It was scoped with public comment in mid-August. It was approved at the beginning of September. This was a mine that has been operating since the 1970s. They were adding a couple of new pits to it. So this one did really seem to fit the idea. There was public scoping, as I mentioned, and then it was approved very quickly. And the idea here is to add life to the mine. So if there is demand for additional coal, they will be able to access those pits if they need it. And if they need additional approvals from the state, they'll be able to follow up at the time that they need it. So you did hear from Dessa about the fact that once the CEQ regulations were removed, the Department of Interior also pulled all of their regulations and are now limited to just 3 topics: categorical exclusions, emergencies, and applicant prepared NEPA. The Department of Interior also issued a handbook, which includes things like no public comment is required on environmental impact statements or environmental assessments, up to the agency. But the department also issued implementation guidance. And I think it's worth taking a minute and reading a few of these provisions that are in the guidance, because what it does is leave it up to the bureaus themselves. So the department doesn't tend to carry out the NEPA, right? It's done by the individual bureaus that may be permitting these projects, the BLM, the Park Service, for example. And what is happening here is this was issued, and while we may see the BLM or other bureaus issue their own guidance, handbooks, or regulations down the road, right now this is what everyone's operating under. So this is what we're seeing on the ground. And you can see here the department is recommending that the responsible officials determine whether public involvement is helpful, because sometimes it might be. And they're recommending early coordination to identify issues that would benefit from additional public involvement, such as economic impacts or effects on quality of life, and acknowledging that members of the public may have unique insight into issues that warrant consideration in the environmental document, such as emerging uses of public lands important to the local community. Now, if you're going to be permitting a large-scale energy project, you may be really excited to get it approved in 28 days, but you're not going to get it done in 28 days. Your mine is not going to be done in 28 days. It's going to operate for decades in a local community. So whether you're a member of the public or a tribe or an agency or a company, you might want to know what that local community you're going to be hanging out with for half a century thinks before you finalize your environmental document. And the guidance continues, consider whether and to what degree, not just public input on what you consider, but also whether their review and comment might be helpful. Consider the following: public interest. What might they be touchy about your project? Complexity. Is it so complex that discussion could generate significant information you lack? Especially if you're going to try to get your environmental impact statement done quickly, it might be good to ask some other folks who live there what they know and you don't. And then efficiency, and I'm just going to point to this one because it's going to be kind of the emphasis here along the way. Would the public input improve the overall efficiency of the process? Again, providing information. And here there is a distinction, I think, sometimes between efficiency and hours or days. Is the project and the review itself more efficient if you take the time to get information from the public? And I think this comes down to this kind of last point I want to just make here, which is, in light of these reforms that have narrowed the baseline requirements we're looking at, the actual process itself is going to get determined by the agencies themselves under this discretion, who are considering whether and to what degree public comment is useful, the project proponents, right, because we now have the discretion in these regulations of project prepared, proponent prepared NEPA, the public who might get some input, tribes who get consultation, who can serve as cooperating agencies. All of these folks are going to affect what these permitting processes look like. In large part, all of these processes, these reforms are opt-in. Project proponent decides, do they want to opt into Fast 41? Do they want to opt into an emergency procedure? Do they want to opt into the One Big Beautiful Bill Act, pay a premium process that Dessa outlined? So there's a lot of folks who are going to have input into what does this process look like. And I think what I want to emphasize is whether or not public comment, public engagement is useful has a lot of different aspects. Could you get more information? Could you have less conflict? Will your environmental document be more defensible? There's a lot of research out there, as well as kind of common sense, that might tell you that upfront disclosure and engagement can reduce conflict, can reduce the challenges, and ultimately may make your document more defensible. There was some discussion this morning in the oil and gas overview of the experience in the 2 administrations ago of what happened to some oil and gas leases that were not defensible. And they were in limbo for a long time while remedial NEPA was being done. So sometimes rushing that might not get you to the result you want. You might be spending a lot of time with the BLM sitting on your bid money, and you don't have it, and you don't have your lease. So there's just a lot of opportunities here to think about this. And these are some examples that I just, saw on a quick look. The Desert Star Critical Minerals Drill Project in the California desert. This is, again, a categorical exclusion. There's no need for public comment. The BLM isn't out there asking for public comment, but they've left an opportunity. You can submit public comment if you'd like to. They're not providing a formal opportunity, but it is under the public comment available. There's a button you can push if you'd like to enter your thoughts on this project. There's a number of these APDs, applications for permitted drills, in the Carlsbad field office, so in the Permian Basin. What these are, they could be using categorical exclusions, they could be using the energy emergency processes, but they're not. They're using environmental assessments, they're providing 30-day comment periods. These are clusters of APDs. There may be 2, there may be 5, there may be 7. There's some roads, there's some tank batteries. They could be doing it in different ways. But here, these are large projects. These are going to be around for a very long time. This is a dense area. This is a community that is very engaged. And these companies are part of the community in this area. So they're giving an opportunity for public comment. These environmental assessments, BLM is not required, has never been required to seek public comment on environmental assessments. It's always been discretionary for the BLM. This is a decision they make. They often consult the company. This is not new. This is how it's done. This is a discussion. This is an assessment of whether and to what degree public comment is useful. You're seeing it in action here. Rainbow East mining exploration. This is a gold project in Nevada. I'm flagging it because, again, under the current NEPA regs, you probably could skip many things here. But what we're seeing is, even though this is an updated plan of exploration, this plan has been approved since the 80s. It's been operating. Originally, this project was submitted in April 2023, the new version in 2025. We're still seeing public comment. Again, because it's helpful, this project's been going on for 40 years. It's going to go on for decades more. Again, Nevada, everyone's used to gold mines, but also everyone's used to having a say. So just to say that while we continue to look at permitting reform and all these new processes, they also may kind of look familiar to permitting that you've been. So I'm going to leave it. I'm going to hand it over to Pilar.
Hey, thank you. Let's see how this, that button. So I'm just going to talk about a kind of a slice of federal permitting as it relates to Indian country, i.e. tribal lands and reservations, and tribes. And while I know there's only one tribe in the state of Wyoming, there are over 100 in the region and in states abutting Wyoming and encircled Wyoming. So a little relevant to what you guys are trying to do here. Just some quick statistics, just to understand kind of the amount of energy resources that are in Indian country. Tribes own about 60 million acres of land in trust or on reservation, about 2% of the land base in America, but have somewhere between, depending on how you measure it, 5 to about 13% of the renewable resources, solar, wind, geothermal, biomass, and hydro. They have about 30% of the coal resources, about 20% of the oil and gas resources, unknown amount of rare earth, because the USGS has yet to conduct a critical minerals rare earth study on tribal lands. But there's been some reporting that about 95% or so of critical minerals and rare earth minerals are within about 35 miles of Indian reservations. So I'm not going to focus on the off-reservation impacts of all of this speeded up permitting, except just to quickly say that, that's going to be challenging for tribes. When you get 24 hours, a week, I think the emergency NEPA is a week's consultation under NHPA, maybe no opportunity to comment. And given that there's a lot of Indian country, especially out here out west, where all this development is occurring around tribes, just don't forget, consult with them. That's all we ever ask. Just pick up the phone and call tribes. Well, let me turn to why our development of projects, energy projects, whether renewable or fossil, is challenging. I'm going to start with a law from 1796 called the Trade and Intercourse Act. It's still valid law. And it says, amongst other things, that no one can convey interest in Indian lands except with the approval of the federal government. So we have several laws that control the ability to lease Indian lands, Indian minerals. The Indian Mineral Leasing Act from 1936 and has not changed since 1936. There's a kind of a replacement law called the Indian Mineral Development Act from 1982. That has not changed since 1982, so our laws are pretty well established and pretty stuck. Those address Indian mineral development, so oil, gas, geothermal, coal, any mineral leasing of tribal lands are covered by those two laws. Our surface laws are the Long-Term Leasing Act for surface leasing. So solar and wind, biomass would be under that. The Right-of-Way Act, of course, is easements, so pipelines, transmission lines, et cetera. We have this thing called the Land Contracts Act, which actually was a part of the original Trade and Intercourse Act, required the government to approve any contract with a tribe. It's now been limited to any contract that encumbers Indian lands. So when you want to do a mortgage on the project that you did on Indian land, you've got to get approval of the BIA for that mortgage. And then the last most recent substantive is the Tribal Indian Energy and Self-Determination Act, which was Title V of the Energy Policy Act of 2005, so 20 years old. And in each of these, there is an element, first and foremost, of the BIA, Bureau of Indian Affairs, we also affectionately say bossing Indians around, of having to approve basically everything we do. And because of that, there's a federal undertaking. There's a federal action related to approving leases and approving right-of-ways. So that means all of these federal environmental laws come into place. So NEPA applies. Whenever a BIA needs to approve a lease, they've got to do NEPA, right? So it depends on the project. Is it an EIS? Is it an EA? Is it categorical exclusion? So we're going through that. We might have National Historic Preservation Act challenges. There are a lot of tribes that have been moved around in this country. So the two tribes here in Wyoming are not actually from Wyoming. And the tribes that were in Wyoming are now in Oklahoma. So if you were trying to do something on some reservations out west, you might have to be consulting with tribes who used to be in that area and have been removed. So even projects on tribal lands where you would think, well, the tribe already understands where all their cultural resources are, and you might have to do some cultural resource mitigation, but you might have to consult other tribes at the same time. The Clean Air Act, Clean Water Act is always going to be implicated. And of course, the Birds, Bats, and Butterflies and Endangered Species Act. So all this gets triggered with projects on tribal lands, and now we're all in the mix as well. So one of the things that tribes are always constantly trying to do, and so this is the federal nexus, right? So our leases and right-of-ways on tribal lands, if we go get federal grants, loans, or assistance, and I know the Fiscal Responsibility Act, the last change in NEPA, they tried to kind of narrow the type of federal assistance that would trigger NEPA, so we don't really know how much money until you trigger NEPA, but I would guess that a $10 million grant would probably trigger NEPA, maybe not a $50,000 grant anymore. We'll see kind of where that comes out without national standards. It's going to be hard to tell, but we do know that at least covers it. If tribes are placing land into trust, and a lot of tribes will have land around them, they'll buy the fee land, and then they'll seek to put it in trust so that it's protected from state and local taxation, comes under tribal jurisdiction. That's always going to trigger NEPA as well. So when that happens, our environmental laws apply. So one of the questions tribes start asking themselves, especially those that are very interested in energy development or are energy tribes, the Wind River reservations got oil and gas on there. They've been looking at wind for a while. So one of it is kind of how do we avoid the BIA? And if we can't avoid the BIA, how do we minimize and streamline these federal processes, taking advantage of our status as governments? So we're not like other project proponents in that regard. So one key set of opportunities, of course, is taking advantage of all these NEPA amendments that would, of course, apply to projects on tribal lands. So Dessa summarized kind of what those changes have been. I'll just point out a few. categorical exclusion. So the new NEPA amendments say that one agency can use the categorical exclusions of another agency. That has actually proven to be very important for the Department of Interior. In the first Trump administration, they went through a process trying to get categorical exclusions identified by tribes in the BIA's NEPA regulations. Several of my clients submitted comments and said, go get the DOE categorical exclusions, get the USDA categorical exclusions for energy. Because they have, 50-acre categorical exclusions, they have size categorical exclusions, they have type of project categorical exclusions. They had to run it up the pole to OIRA and OMB, who sat on it for the whole time. Now, you would have thought that the first Trump administration would have been, yeah. So it actually took the Biden administration to do it. But now, as we identify new categorical exclusions, as other agencies do, now the BIA can automatically adopt those. But we also have encouraged the BIA to ask the tribes what kind of categorical exclusions might work for particular tribal projects or particular tribal lands. Tribes can be joint lead agencies under the new amendments. So take advantage of it. So how do we, if we're a project proponent and we think the BIA is going to drag their feet, or there's not enough staffing at the BIA to do the project and get it through quickly, then let's promote the tribe as the lead agency and have them take the lead on doing all the NEPA work. In the old regulations, well, the first Trump administration's regulations that they amended, they actually encouraged federal agencies to use tribal environmental documents. The Biden administration kept that when they started repealing the Trump administration regs, but now they're all gone. So we still want to try and encourage the agencies to accept environmental documents. In the leasing regulations for tribal surface leasing, there's actually a provision that says if the tribe has complied with the Bureau's, and by the Bureau, I'm sorry, Department of Interior's leasing NEPA process, then the BIA will accept those environmental documents. Well, since we now know that their NEPA process is 3 things, then that should be relatively easy to do. So we now can kind of piggyback off of the streamlined permitting. And if the tribe is the joint lead agency and the project proponent can do all the NEPA work, which they're going to do anyway, and we combine that with the tribe being the governmental entity that is acknowledged in the law now, then we have a much faster process, less reliant on the federal government, which is critical, again, especially if tribes have not yet taken advantage of some of their, what I call self-determination opportunities. The DOI, I call it emergency NEPA. What did you call it? Alternate NEPA? Alternative NEPA? Emergency, energy NEPA. We just call it the energy NEPA. Of course, it's only oil, gas, geothermal, doesn't apply to solar and wind, as we know. But it's also not explicit that it applies to tribes. So we have encouraged the Department of Interior to clarify that it does in fact apply to projects on tribal lands. They've taken some comment on that, but we haven't really seen much clarification. Now, having said that, we have timelines, right? 1 year, 2 years. We have the SPEED Act. We'll see if it gets passed. But that's clearly in this administration, and at least for Indian energy development, a challenge because most tribes don't have oil and gas. Most tribes don't have coal. I can count on 2 hands the number of tribes that have fossil fuel resources that are developable. But 150 tribes have solar and wind resources, and about a dozen of them have been actively looking at deploying those on a commercial scale basis. So even though the law now says you've got to do NEPA in 2 years or 1 year, depending on the size of NEPA, EIS or EA, the department's new guidance memo related to solar and wind says we're never doing it. So there will be an interesting opportunity for those tribes that are doing solar and wind development to litigate the question of whether this guidance memo, which purports to apply to tribal lands, it's the first time the BIA or the Department of Interior has said what we do on BLM lands will also apply on tribal lands. They almost always treat tribal lands different. Why? Because the tribes should be able to decide for themselves whether they want to develop solar or wind or their oil and gas or their coal, and make those decisions without the Secretary of the Interior having to be the one saying, yes, you can do it. Those days are long over. They've been over for 50 years, but yet now they're back. And so, this administration appears to hate solar and wind more than they like tribal self-determination. So we'll see what happens when the NEPA deadlines meet this guidance memo, especially for, again, tribes that have solar and wind opportunities. One other thing I didn't make a note of, but let me just quickly mention, is there are still other regulatory opportunities. So these laws that I listed earlier all have a set of regulations that go with them. And there's every now and then the BIA will think about maybe revisiting their regulations. We are constantly asking them, please revisit, especially your oil and gas and your mining regulations, because they defer to BLM regulations when they do that. And since every time it seems like BLM changes their regulations, Congress overturns those new changes through the CRA, we're not really sure what's going on. So, but there are opportunities for the department to go in and update some of those regulations. The oil and gas regulations are 40 years old. The coal regulations are 50 years old. So really would be ideal for them to really revisit that. Lastly, let me end. So one of the things I always just try and tell tribes, I teach Indian energy law, so I teach my law students the same thing. Why are we even bothering with the feds? Let's figure out how we do it ourselves. So as I said, the Trade and Intercourse Act says you can't convey any land without federal approval. So Congress has found a way around that, in which they have passed laws that have said, if you get our approval, you can then do it yourself. So we have things called, for example, tribal energy resource agreements. Those were first enacted in the Self-Determination Act of 2005. A tribe can develop what's called an energy resource agreement. Nobody really knows what's in it because nobody's had one approved yet. But if it's approved by Interior, then the tribe can enter into its own leases, its own easements, its own business agreements, and then can regulate all energy minerals and resources without further DOI approval. There are limitations on the length of the agreements, and there has to be a robust environmental review process, but it's not NEPA. It's a tribal environmental review process. That same law also authorized what are called tribal energy development organizations. These are organizations that have to be at least majority owned by a tribe, so 51%. The other 49% can be somebody else. If they get certified by Interior, then tribes and TITOs can enter into any kind of lease, again, oil and gas lease, mineral lease, without further DOI approval. So those lease approvals would be all subject to just tribal law. Tribes have what we call Section 17 corporations. They are from the Indian Reorganization Act. Under their charter, if their charter authorizes it, they can lease land without DOI approval. And then lastly, the Hart Act, which was an amendment to the Long-Term Leasing Act in 2011 or 12. If a tribe submits its own leasing ordinance or leasing regulation to Interior, and as long as that leasing regulation is consistent with Interior's regulations, and there's an environmental review process, but not as bad as the Terra, then they can enter into surface leases without Interior's approval. So, and it's a minimal environmental review process. 0 Terras, 115 Hart Act leasing regulations. So, so we finally got it right on how to get tribes this self-determination. And then lastly, I would add that, tribes also can get treatment of state status under the Clean Air Act and the Clean Water Act. So where there are jurisdictional waters, in Arizona, we don't have any anymore. You have jurisdictional waters here. Wind River had a big fight over kind of the scope of the reservation for their they applied for task status under the Clean Air Act. And so there's still some of that kind of question of the scope of a tribe's jurisdiction, but that's another way for tribes to fully regulate their own energy development and energy production. Southern Ute, which is in Colorado, does their own permitting under the Clean Air Act for their oil and gas development. So these are some ways for us to get around the federal permitting process, replacing them with tribal permitting processes. But again, just a slice of how we can take advantage of what the feds are doing and use it to our advantage to develop our own energy resources.
Okay, thank you, Pilar. We'll finish up with Anna.
Thank you all. Whoa. Let's try that again. I just got to say, this is an impressive group of ladies. I'm honored to be up here with them. So, good afternoon. My name is Ana Gutierrez from Womble, Dickinson down in Denver. Don't hold it against me that I'm down in Denver. I promise I have Wyoming roots. My mom's from Casper, licensed here, do a lot of work up here in Wyoming. So, it's good to be here with you all. So I have the privilege of really rounding out the discussion this afternoon and really at the close of this conference to talk with you about the court's role in NEPA and federal permitting. Well, I think this could be an hour or more presentation on its own. I'm just going to focus on two cases, Loper, Bright, and Seven County, which Dessa staged for us nicely, because those are two, both coming out of the United States Supreme Court, that have been and will continue to be extremely impactful. So starting with Loper, Bright, for 40 years, I think most of you in this room will know this, we operated, past tense, under the legal principle called Chevron deference, right? So under that principle, when laws were unclear, an agency would take the time to interpret this ambiguous rule, they'd take an action, make a decision, and then let's say that action was challenged, it went to the courts, and the court said, you know what, this agency has more experience with this law than I do, I'm going to defer to the agency. As of June 2024, that all went away, and we entered with Loper, Bright. So in terms of basic facts, this case involved a fishing company that sued the National Marine Fisheries Service. The underlying statute is not really relevant to going into Loper, Bright, but basic facts is that the fishermen were arguing that the services unlawfully required them to fund third-party observers on their boats. The DC Circuit said we defer to the agencies, and they cited it to Chevron deference. Now, SCOTUS took up a question that was much more than the fisheries decision to charge these fees. They took up this case to reconsider Chevron deference altogether. Ultimately, the Supreme Court, in a 6-3 decision, ruled that the courts have to exercise, not choose to, they have to exercise their independent judgment when it comes to questions of law. I think, went too far. This is an incredibly, incredibly important decision in all federal permitting. It meaningfully and dramatically changed the landscape of APA litigation, and I think you all know this, but that's going to inevitably impact all NEPA litigation, right? Kind of citing back to what Dessa said, when the SPEED Act here is trying to revise APA, but our baseline here when we're going into NEPA litigation is the Administrative Procedure Act. So with Chevron deference gone, we're now not going to rely on agencies to look at ambiguous questions of law. And the court said that this decision was grounded in both the APA and the Constitution. And they declared that when you look at both the APA, the language there that you're seeing on your screen, as well as the Constitution, it's truly the job description of the judiciary to take up questions of law. It's not the rightful place of the agencies to be taking up these questions. I do want to take pause here. I think it's my second to last bullet, which is the smallest bullet, but I think incredibly important. The court was really careful to say that the agency's view may be informative, but it can't bind the courts. So this is a 1944 case called Skidmore versus Swift. I think this particular discussion in Loper Bright has yet to really be leveraged and explored in litigation now that we don't have this reliance on Chevron deference. But take any, that can be in your favor whether project proponent, or that cannot be in your favor as project proponent, right? But if you're wanting to intervene and support an agency decision, you may rely on Skidmore deference to say, look, this agency has been doing this for so long, this is why they've done it, this makes good sense. Take this under advisement, but weight it heavily, right? I think we're gonna see more and more Skidmore deference backfill Chevron in its absence. I think one other key point is the court was also really clear. I think one of the concerns when this case was going up to the Supreme Court is, what about everything that's been decided under Chevron deference? Does it all fall away? We no longer have a body of case law. The court did address this and said stare decisis does preserve those previous decisions that relied on Chevron. So you can take pause in decisions that have been made, but that's not to say those decisions might not get relitigated and decided a different way. So I think those will come back again. Given our time this afternoon, I'm not going to spend too much time on the dissent, but I do think it matters that there is one. And I think it's important to just be mindful that it was really, really critical of the majority opinion, referred to the decision as a wrecking ball to the structure of modern government. So some heavy words thrown around at the Supreme Court, but it also goes to, this is it's a heated debate, right? And it's one that's going to continue. We do have Loper Bright. It is the rule of law, but I still think there's going to be ways in litigation that folks are going to try and find their way back into this Chevron type space. So then, less than a year after the shakeup of Loper Bright, 7 County delivered another seismic shift, and this shift is directly focused on NEPA, as Dessa again stage set for us here, and she gave us the prime example of the direct implications of NEPA by talking about the Speed Act, and now we're seeing it in intent to codify that and how it's so impactful for projects on the ground. In terms of facts, the case was a typical project development case. In this particular case, it was a railroad, 88-mile railroad, and the U.S. Surface Board of Transportation had to authorize the railroad. That, of course, was a federal action. That tripped the trigger for NEPA. A comprehensive EIS was prepared. It was some 3,600 pages, which is like excessive, but 3,600 pages. And then once it was approved, it was challenged. Both the DC Circuit and the lower court held that the Transportation Board failed to consider, quote unquote, reasonably foreseeable impacts under NEPA. So then we go up to SCOTUS. And the question then for SCOTUS was this question that has been percolating, and probably everybody in this room who's come across a project or proposed a project or been a part of a project, what is the scope of NEPA? Where do we start? Where do we stop? And what does that look like? And the court took that up. So the majority of, this was an 8-0 decision, and in the space of NEPA, I think that's pretty tremendous, but the majority opinion delivered what is called a course correction of sorts, and they upheld the Transportation Board's decision to approve this 88-mile railroad, and with that, approved their scope of NEPA review in the EIS. If you guys have not read this opinion, please do. It's so fun. It's like, it is, Kavanaugh must have had a day and got a little punchy and put all the wittiest statements in this thing. It will be cited for decades upon decades upon decades. It's that line that you've always wanted to deliver in your briefs. This is the case to cite. I think there's 3 key elements that come out of 7 County that are beyond the case itself, but are incredibly important to every application of NEPA, every federal permitting that we're going to step through from here. The first is the question of deference. The court called deference the quote unquote bedrock principle in NEPA cases. So Loper Bright, your first question might be, but I thought you just said Loper Bright took away deference. Not true. Well, limitedly true. Loper Bright took away deference when the question of law was ambiguous, right? How do we interpret this thing? Agencies don't get to do that. Courts have to do that. But in cases like 7 County, where there's a question of the agency exercising its discretion granted by statute, or analyzing an issue of facts, which is almost always NEPA, we still have, the court said, the APA's deferential, arbitrary, and capricious standard. Now, citing back to Dessa full circle, this gets a little bit sticky when you're talking about the Speed Act, which is trying to change or impose upon the APA. So we'll have to see what happens there. But under 7 County, we're operating under an arbitrary and capricious standard. And in fact, it might be an even more intense level of arbitrary and capricious standard in the NEPA world. So what does that mean? That means when we're litigating questions of agency detail, agency impact, scope, now we're living in an extreme deference world. The other, one of the other, I think, themes that comes out of 7 County that's really important for us to all take a moment to think about is going beyond deference. The court said, even if this EIS falls short in some respects, that's not necessarily reason to vacate the underlying approval. We just have to take pause there. So even if the agency didn't do it quite right, maybe it's good enough, is essentially what the court said. And the court said the question we're asking is, was there a reasonable explanation? And oh, when you're evaluating whether there was a reasonable explanation, this zone of reasonableness is really quite broad. So it's a really expansive world, and not only are we giving agencies extreme deference, but this rule of reason that we've sort of lived under in the space of NEPA has now grown a bit. So a lot of things that may not have been reasonable in the past are now reasonable. Now, I think a lot of folks might say, that's great. That means everything the agency does is going to be approved or not challenged in court. But that might not always favor you if the agency's decision is not what you were looking for. So we have to be careful with how these decisions move through, what facts are they assessing, and ultimately what they have decided. I think one thing that's in this zone of reasonableness, what the court talked about was what they're looking for in an EIS is essentially a report. So I think, and they used that word, right? We were looking for a quote unquote adequate report. So that again projects a space of NEPA and a process that is hearkening back to this is a procedural statute, but I think it's removing any, if any, teeth that were dictated by statute. The last rationale, or the last piece I want to talk about, all this rationale led to the conclusion that the Transportation Board did not need to look at the upstream impacts from oil and gas development, because this railroad was going to tie upstream impacts, downstream oil refining, and they didn't need to look at these impacts nor these impacts. Part of the sort of disconnect was that the Transportation Board, they had no approval authority over what's happening in oil refining. They were not improving these oil and gas leases, and they were too far removed in space and time. Lots of fun, fluffy words that us lawyers are going to have a good time with over the next decade, but it also does have some sharp lines in there too with, are you issuing the permit for that part of the project or not? So I think there are some clear lines drawn on reasonably foreseeable impacts. I think when we are talking about what is the quote unquote project at hand, what is the project, depending on the facts, right? And 7 County was pretty clear cut in terms of here's your railroad and here are these other things. But you're going to have projects that are going to be a little bit more interpretive on who has the authority over what and how interconnected are these things. So I think while this came out clearly for this particular case, it might not be the case in each of them. And mindful of our time, Maddie, I know.
Well, thank you each so much. This has been so interesting and just as remarkable as I had anticipated, hearing all your perspectives brought here together. We do have a few minutes for questions. I'd love to open that up to the audience.
So I didn't hit key insights just because I'm mindful of time, but you guys can have a look-see at your screen and happy to answer questions.
One question I had, when I did an analysis of the Department of Energy NEPA changes after they came out, one of the things I noticed was a wholesale removal of segmentation out of the regs, the mentioning of segmentation, and there's one passing mention within the implementing procedures, I believe is the term of art that they used for that. Are we seeing generally that the notion of causes of action challenging NEPA under a theory of unlawful segmentation, is that now defunct as a potential recourse for litigants who want to challenge agency decisions?
I'm happy to take the first kick at this, and Dessa, if you have some thoughts as well. My reaction is no. I don't think the theory of the argument is dead, but it's going to be incredibly fact dependent. It's going to depend on how close in time are these projects that you're saying, draw the line here and don't look at this, but close your eyes to everything else. It's just going to depend on how closely tied they are, both in terms of who's controlling it, is the pipeline connected, how quickly in time are these happening. So I think we'll see some segmentation arguments where there are truly some separate projects that happen in separate spaces and times, and then we're going to see some that, nope, you're doing this thing together, you need to have a look, see at the NEPA together.
I just add briefly to that, if you take a look at 2 weeks ago, the CEQ issued its draft regulations for agencies to consider. And it preserves the concept of connected actions, which is, of course, part and parcel to segmentation. And Seven County itself includes this exception for interrelated actions that are permitted by the same agency. So I agree. I don't think that's dead in terms of a litigation concept.
The nuclear panel is coming in clutch.
That's okay. I'll ask a question I know nothing about, which is tribal law. You mentioned the bossing Indians around part of the Department of Interior, which I thought, I haven't heard that acronym before, but it sounds terribly appropriate. I was just wondering if the tribe wants to challenge the BIA disapproval, is it still an arbitrary and capricious standard, or is it more of a trust responsibility? I mean, what is the standard the courts are going to hold BIA to if they're going to say no to a tribe?
So, so the BIA rarely says no anymore, especially under the current leasing regulations. They have written into their regulations that they have to substantially defer to the tribe in the leasing decision and the terms of the lease. The law still requires a best interest of the tribe analysis. So the BIA is supposed to do that, but they defer to the tribe. So what tribes will do is write into their resolutions or into the lease itself that the compensation and the lease terms are in the best interest of the tribe's determinants in the best interest of the tribe. And the BIA just says, okay. We'll see if, I was talking last night about an example from the Bush administration where they denied a lease for a tribe that wanted to lease their land for spent nuclear fuel in Utah. And the rationale was the best interest of the tribe. And the court overturned that BIA decision and looked at kind of how they evaluated the best interest of the tribe. And it was, it seems subjective, but the court had some pretty good, and the tribe, of course, sued. So the idea of what is in the best interest of the tribe, the BIA itself is all over the place. It's not necessarily maximum economic value. There's a whole bunch of factors that they put into that, which makes it really squishy. So we'll see. I think, in the guidance memo, I think the challenge is really going to be that their failure to act is arbitrary and capricious. So I send you my lease for a solar project, and the secretary sits on it under this guidance memo because he has to personally approve every step of the way. So if I've got a year to do my EA and I don't meet the year, first of all, I don't know what the enforcement for that is anyway, but other than suing you to make you do it. So I think that we're likely to see that kind of litigation because they just refuse to act than they say no. And they won't say no. They never say no. They always just refuse to act.
All right. Thank you. I think we're out of time, so we'll leave it to Temple to give closing remarks. And thank you to our panelists. This has been wonderful.
Great. Well, I think you were well rewarded for sticking around for that excellent panel. So that was really insightful. Thank you. I'll just keep things short and sweet and just thank you all for the time here today. It's great to see so many of you in the room. We've decided we're going to host this panel on a biannual basis. So, and we're going to rotate that with the School of Energy Resources WOLD Conference on Energy Technology. So next fall will be the WOLD Conference, and then the year after that, we'll come back to the Energy Law and Policy Conference. But thank you all. This has just been terrific today. I hope, like me, you've enjoyed your time and learned quite a bit from all of our wonderful speakers. And we hope to see you again maybe next year for the WOLD Conference, and if not, for the Energy Law Conference in 2 years. And if you're still in need for CLE, please come to the CJ Box Symposium on Saturday. All right, thank you all. Safe travels.